Morning, everybody. It is 11 o'clock. My name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm, and we are going to go ahead and get started with this webinar. And I don't want to keep you here too long this morning. We're probably going to be here about 30 minutes. I'm going to go ahead and get started. If you have questions, feel free to ask them. I might address them as the presentation continues. But with that being said, like I said, we'll go ahead and get started. Again, my name is Jordan Walker. I'm with the law firm of Seaver Walker Paget Law Firm. That is my contact information right there. You can see it there in the bottom. If you have any questions, like I said, you can text me at that number. You can email me at that number. You can take a look at our website, www.landownerattorneys.com. A lot of information there if you didn't get what you need at this presentation. So real quick, before we get into exactly the meat and potatoes of the presentation, I want to do some more introductory information. One question we get a lot is why did the landowner receive the letter that we sent? The reason that you received the letter that we sent is because according to our research, your property is possibly going to be affected, is in the path of a road project. And the reason why you received it now is because further, according to our research, not only is your property, in the path of a project, but the DOT has already begun to acquire at least a portion of the land elsewhere on the project. So basically what we do is we monitor projects, and we recognize that at least some of the other parcels have already been acquired on the project that is affecting your land. And that informs us, and that informs you that they are in the land acquisition process or phase of the road project that affects your property. This is all to say that we believe, in the near future, possibly up to a year, you may receive an offer from the DOT for your land. Now, of course, we don't work with the DOT. We are landowner attorneys. We represent landowners only. We don't work with the DOT. We don't work with the state, the county, municipalities, etc. So we don't have access to the specific information as to when they're going to acquire your property. We kind of have to approximate based on the limited information we have. But this is all to say, of course, that we believe there's going to be a project coming. It's going to affect your property, and that's why you got the letter. I already touched on this, who we are. Again, we are a landowner only law firm. We are an eminent domain only law firm. Seaver Walker Paget only does eminent domain, and we only work for landowners. And so as a consequence, because this is the only type of law we do, we've learned quite a bit about eminent domain and how this process works. And our job today is to relay to you what we've learned effectively, and to inform you of what to expect when the DOT comes in and wants your property. And what we're doing today, again, is just relay that experience, tell you what to expect and what to do when they come in and start making offers. And that's what we're doing today. What I've already said it a couple times, but real quick for those that don't know, eminent domain, a lot of people ask me, what is eminent domain? And eminent domain is the power of generally the government, although other entities have this power, to acquire property and set it to a public use. Meaning ultimately, you can't stop the taking, stop the acquisition, such that if the DOT has determined that your property is needed and they follow the law in the acquisition of your property, that you can't stop it. In other words, you can't say, I don't want to sell to the state. I want to keep my land. Ultimately, if they want it and they follow the law and it's for public use, they can get it. And that really is eminent domain. It's the power of the government to take land from private landowners and set it to public use. So that's the power. That's where they get their authority to do what they're doing on your land and for the project that's affecting your property. This is a rundown of the eminent domain acquisition process in the state of Georgia, as well as some very, very rough timelines. You can see that on day 0, or the beginning of your, as we deem it, that land acquisition process, day 0 would be the appraisal inspection letter. What I tell people is the first notice you're going to get that your land is affected by this project besides going out and going to public meetings and making yourself present in the public scoping process for any project, the first communication you're specifically going to receive from the DOT that informs you that they're going to come in and acquire your property shortly is the appraisal inspection letter. And the appraisal inspection letter will come from a contractor that is hired by the DOT to appraise your property for the acquisition. So in other words, the DOT goes out and they hire a bunch of contractors for any project, serving any number of functions for the project. Included in that is land acquisition. So they get these third-party third-party appraisers. And under Georgia law, before they can do anything in the form of negotiating with you, they need to appraise the property. And not only do they need to appraise the property, but they need to inspect the property. And beyond that, they need to provide you notice and allow you the opportunity to be there present during the inspection. You don't need to be there. A lot of folks aren't present during the appraisal inspection, but you are allowed the opportunity. And this is a relevant point in the process because again, I tell people this is the first time you're going to know that they're coming in to acquire the property. Road projects exist, kind of as nebulous concepts for a while. They happen, they're on, they're off, they're going to happen, they're not going to happen. Ultimately, for a landowner, what they need to keep their eyes out for purposes of their land is the appraisal inspection letter, because that'll tell you that the next step after that is an offer. And that's the next step that I've detailed on this slide. And that is somewhere about a month, 2 months after the appraisal inspection letter, you should receive an offer. Now, I want to be clear here that these timelines are incredibly rough. Again, the scheduling of GDOT and these projects is very it's hard to tack down. They change pretty frequently. Properties are appraised and offers aren't issued. Offers are issued and then the offers are rescinded and then reappraised. So it's not this is not a hard and fast schedule. This is a very rough schedule. This is assuming that there are no complications with the DOT for their acquisition. But roughly 1 to 2 months after that appraisal inspection, you will receive an offer. You should receive an offer, and that offer will be based off that appraisal that's already been performed. What I tell people is that's when our firm gets involved. Our firm gets involved with landowners when the offers are issued. So as soon as you have an offer, if you're interested in knowing if it's a good or bad offer, you can send that to me for free. I can look at it and give you my thoughts. We'll get into that more here in a bit. But back to the schedule. So the 1 to 2 months after the appraisal letter has been sent, you will receive an offer. We'll get into what these offers look like and then negotiations. Let's say a deal cannot be reached in pre-suit negotiations. The next step is, well, GDOT needs the land or the DOT needs the land. So how they get that is they exercise their eminent domain authority to acquire the land via litigation or a lawsuit. So they'll file a lawsuit. So back to the beginning, you got the appraisal letter. They come out, they appraise the property. They did a terrible job. They give you an awful offer. It's not even close to what your property's worth. And there's no way you're going to accept it. So what happens then? Well, they need the land. So they go to the local county court where the property is located. And they'll file a condemnation petition. Condemnation, for your purposes, is just another word for eminent domain. Condemnation is the procedure by which the power of eminent domain is exercised. And so you're looking at about 3-4 months after you've got that appraisal inspection letter. They've filed a lawsuit against you and they've served you with that paperwork and you are in eminent domain. Now, what I tell people with regards to eminent domain is that, if you have reached that stage of the process, what I tell people, you're in court, you've been sued. What I tell people is that if you have reached this point of the process, you should want to be in eminent domain. Eminent domain is not a scenario you just want to find yourself in. In a lot of these cases do not require eminent domain, and you can actually get them done with legal assistance, in our experience, prior to condemnation cases being filed. And oftentimes that's advantageous for the landowner because you get your money sooner. The process is much quicker, and you don't need to deal with everything that comes with litigation. Now, on the other side, on the flip side of that, is that oftentimes the DOT is not going to get where they need to be to properly compensate you. Let's say they're destroying your business and your business is incredibly valuable and they're not offering you one dime for that business. That's a case, and they've refused to negotiate. That's a case that you would want in eminent domain because otherwise, if you avoided eminent domain, domain, that means you probably are settling for an amount that doesn't properly compensate you. So again, the takeaway from this is that if you get to eminent domain, if you've filed if the DOT is filed against you, you should want to be there. That should be part of your plan. It isn't something that you just happens because it might not be a great situation for you. And I can tell you that in our review of your offer when you get it, if it's a case that I feel requires litigation or won't. So this is the beginning to the end. I will say that, and ultimately at the end of this process, you are entitled to a jury trial over compensation at eminent domain. So you have that ability. I will also say that most cases, even the ones that do get to litigation, do not reach a jury trial. I'd say 95% of our cases settle at some point, either pre-suit or during litigation. So something to keep in mind. Not a lot of these cases go to trial, but sometimes they do, and we will absolutely do that if yours is one of them. So we talked about the land acquisition process. Now we're going to talk about what to do when you get into the negotiations with the DOT when they come in, make those offers. Here's what I tell people to do once they receive their offer, because there's a lot of instincts that kick in when they come in and start making these offers. There's an instinct or an impulse to start negotiating, start throwing out numbers, seeing what they'll accept, seeing what they'll take. The problem is that all these communications with right-of-way agents, with the DOT, who will be different from the appraiser. These are different entities, different contractors. There's an instinct, there's an impulse to just start communicating. But like I said, or like I was going to say, rather, right-of-way agents document all these conversations. They take contemporaneous notes. They are taught to do that. It's part of their job. So anything you say to them, even verbally during these discussions, will be written down, documented. So you start throwing out numbers that you think you might be entitled to. Well, let's game that out. Let's say you're offered $10,000 and you think you're entitled to $30,000, and you threw it out there and you said, I want 30. And they said, we can't do 30. And then you called me up and I look at it and I noticed that wow, this is actually much worse than you thought. You actually should be getting about 100. Well, the problem there is that you've already told the right-of-way agent that you'll take 30, and that'll be documented. It'll stick with your file, and it'll be with that throughout the rest of your case whenever it resolves, including through litigation. And I think the takeaway from this is that not to reveal your hand. And if you're revealing your hand, you need to make sure that you're coming from a position of strength. And coming from a position of strength means you know what you're entitled to under the law, and you know what your case is worth. And though a lot of landowners, of course, sometimes feel like they have a grasp on what their property's worth, and they might be right. With a lot of these acquisitions, they aren't very clear cut and dry, especially because they're partial acquisitions, meaning they only take a portion of the land. And valuing partial acquisitions is very difficult. Usually only appraisers can do it. So this is all to say that we generally don't advise getting in there and start negotiating with right-of-way agents, at least before you have had a chance to talk to an attorney or somebody who knows what they're doing, knows what they're talking about. What I tell people, and to avoid this problem altogether, and to avoid any hiccups and avoid any problems you might have with negotiations, what I tell people is as soon as you get the offer, or as soon as the right-of-way agent starts communicating with you, telling you that they're going to give you an offer, insist that the right-of-way agent communicate with you via email only. Insist that they send their offer packet via email. They're going to want to do a lot of things in person. They're going to want to do a lot of things in person, and they're going to want to because by doing it in person, they're allowed to say things verbally that might not come to fruition. They can pretty much say whatever they want. A verbal promise means nothing. So anything that they say verbally ultimately also means nothing, which is why I tell landowners to avoid in-person discussions altogether and to create a record of these communications. The easiest way to create a record of your communication with the right-of-way agent is via email. Just insist on email communication only. They will absolutely do email only. They don't like to do it. They want to get you on the phone. They want to talk to you in person because that's how they get these deals done at low numbers. They want you to have these, kind of informal discussions where verbal promises are made that aren't necessarily ultimately upheld. So you can avoid all that by just insisting on a email communication only. And this allows them also it allows you the ability, I should say, to easily give your offer package to me or someone else for review because you can just forward it to me as opposed to scanning or taking photos. So what I tell people again is as soon as you get that offer or as soon as they intend to issue it to you, say, send it to me via email. And then they'll want to talk about it. They'll do a follow-up. And then what I tell people is just say, when you get the offer, say, thank you. I will review this and get back to you in a week. You're not putting anyone off by giving yourself a week to do your due diligence. They're not going to go back to GDOT and say, let's file condemnation. It doesn't happen that quickly. As long as you let them know that it's on your radar and that you're considering it, you're looking at and you're reviewing it, they should give you the time to do that, and that'll give you enough time to contact an attorney for that advice. So just say, thank you, I'll review it and get back in touch with them in a week. That'll put them off. That'll give you time you need to do your due diligence, which can include, of course, contacting an attorney, myself, if you wish, for review. And again, we review these offers for free. Our firm only gets paid if you're our client. So we don't bill, we don't charge for these case reviews. We do them as a matter of course. So feel free to send me any offers you might have and I will review it for free. Again, final takeaway, avoid in-person discussions and negotiations. So that's what you should do when you receive your offer. Here's what you should not do. Don't just hop into negotiations and value discussions. It is, again, we already talked about why you shouldn't do that, but again, you might not know what your property is worth. You might not know what the impact of this acquisition could mean on the property. So it is not smart to just jump into discussions with the DOT without talking to somebody first. Don't hire an appraiser without, unless the attorney says you should, or at least, or the attorney has an appraiser that you should get. So they have their appraisal, and it's a lot of times people think, and I think it's common sense to think, well, I'll just get my own. I don't advise doing that. I don't advise doing that for a couple of reasons. One, it's not always necessary. A lot of times, and I can only speak on behalf of my clients, but we're able to get deals done with the DOT without getting appraisals. And in going to my next point, these appraisals are not cheap. Eminent domain appraisals will run you, depending on the type of property and the type of acquisition, between $5,000 and $10,000 if it's a good appraisal. They are not cheap. And there's a reason for that, is because they are very difficult appraisals to do. Very few appraisers can actually even do or are qualified to do eminent domain appraisals. And beyond that, you want to make sure your money's worth it. So if you're spending that type of money, you want to make sure that your appraiser is vetted, has testimony experience, has gone up against the DOT before, knows what they're doing, does not produces work product that's admissible and it does not rely on inadmissible evidence, rendering it worthless. These are all things that need to be considered before you get an appraisal. And that's why I tell people, and my general policy is with my clients, because I don't like spending money on behalf of my clients that isn't necessary. And if it's not, in my view, is that appraisals are not necessary unless you get to litigation. Sometimes they are necessary, and usually at eminent domain litigation, they are necessary. Not always, but most of the time. But a lot of times they aren't. Usually, if your case is getting done pre-suit with our firm, generally you're not going to require an appraisal. So I'm not going to spend that money, and I don't want you spending that money that you don't need to spend. So don't go out and get an appraisal unless you absolutely have to. And if you do, it's got to be worth it. And we know the appraisals that are the appraisers that know how to do the job, do it well, and are qualified. Again, do not meet in person with the right-of-way agent. We've talked about that. don't make a rush decision. And I think if you follow my instructions on the last slide, you will not be making a rush decision. Don't rush into a decision. That a rush decision is usually a bad one, and the DOT loves that because it means you probably are taking a bad deal and saving them money. But also don't ignore this altogether. You're not ignoring that because you're here at this presentation right now. But a lot of folks don't want to deal with this. They hear no evil, see no evil, put it aside, and don't acknowledge it. That's a bad course of action. And I would generally advise to attend to this matter as we've instructed, and to not just let it by the wayside. I've had countless number of folks contact me. They've been sued. They don't know what to do, and it's not a case we can take on. And I can't help the landowners out. My advice was, well, this is probably a case you should have settled without going to court. So these are just pitfalls. That's something that can happen if you ignore this and not address it and just let it lie. So something to keep in mind. But if you follow our instructions, you should be okay. So I want to talk about compensation now and what you're entitled to, and how is it possible that the DOT appraises these properties and they are so bad. And we'll get into an example of that in the next one. But every case is going to have several of these keys. They might not have all of them, but each of these topics should cover all the types of compensation you can get. So, for example, every case is going to have to deal with the value of the acquisition, and that's just the value of the land. How much is the land worth? How much are they offering you for the land? And what type of comparable sales are they using to support their land valuation? And what type of comparable sales are you using to support your valuation? The key to the value of the land, as you might imagine, the DOT will often look at comparable sales that are not comparable. They will look in jurisdictions far, far away to get low value comps to undervalue your property and lowball you. It's important. It's imperative on you to find these appropriate comps and make the argument for appropriate valuation of the land. Land value is a component that everyone's going to have to realize unless you're just a tenant and you don't own the land. But if you own the land, land value is, of course, very important. And that's going to be an issue for everybody, is to ensure that the value of your land is appropriate. The second aspect, and this is for partial takings only, and I touched on partial takings earlier, but a partial taking, in short, is just when they are taking something less than the entirety of your property. If you have a 5-acre tract, they're only taking an acre, for example. And the question is, for remainder damage and consequential damage, they mean the same thing. And that is, what is the impact on the remaining 4 acres from the acre acquisition? So in that situation, you have 5 acres, they're taking 1 acre. How does that acquisition affect the remaining 4? And the reality is that effect can come in an endless number of ways. For example, let's say if they're taking your access, if they take your parking or a portion of your parking, if they increase or lessen, I should say, the proximity of your home to the roadway. And this is called setback. If your home's closer to a road, it might lose value, and you are entitled to the difference in the value of your home before and after. If your commercial property can't be, if there's no internal circuity within the property, you can't, customers can't get around. No one can get around the property. If you can't get around the property loses value. If your property becomes zoning non-compliant as a consequence of an acquisition, even though the DOT caused it, that can be a problem for you that you'll need to fix, or it becomes a problem for your property, which may lose value. All of these are just examples of how remainder damage can realize itself, and that it can come in many different forms and many different shapes. But the long and short of it is that a lot of times these acquisitions, because of course people build properties and they build to suit properties, and they don't expect that somebody's going to come in and take a portion of their land. And so on build to suit properties, or properties where the buildings are tailored to the parcel, even small changes in the parcel can have huge impacts. People rely on the property always being there, and then all of a sudden it's gone. that has a big impact a lot of times. So it's imperative that you get paid for that as well. And then the third component, and this is a big one, and this is one that the DOT will, as a matter of course, the Georgia DOT will, a matter of course, not offer. They don't offer business losses, even though they are compensable in the state of Georgia. The state of Georgia is unique in this regard in that they allow business loss recovery. If your property was in another state, you would not be able to. There's a decent chance you would not be able to recover business losses. I believe only 20% of states, I think maybe even less, have allow business loss recovery. Georgia is one of them. Nonetheless, the DOT does not offer them, so it's going to be incumbent on you to get them and to secure those business losses if they exist. So, and it can be gigantic. Businesses, we've dealt with some huge businesses that get impacted, they can't be relocated, and the business has been effectively acquired. It needs to be paid for, and the DOT often doesn't offer anything for it. So that's on you. If there's a business loss impact, you are going to need to fight for it. It is something that they do not even offer. And then finally, if you have a total taking, meaning it's taking your residence or your business, you're sustaining a total taking. Meaning whatever's on the property is going to need to be relocated somewhere else, residence or business. You are also entitled to relocation expenses. They will offer them, but just like everything else, they are very likely to be deficient and not be satisfactory to relocate whatever is being relocated. So just like they undervalue the offer, they will undervalue your relocation as well often, and keep that in mind as you review those offers just as well. Okay, and we are approaching the end. I have a couple more slides. I want to just provide an example. This is a real life example, an offer to one of my former clients. Obviously, it's been redacted, but I want you to see this so you know what the offer looks like, and you know what it's going to look like. And you see, it's called the summary statement basis. Summary statement basis for just and adequate compensation. They'll give you the project, the county, your parcel, of course, all the information about the parcel. And then here's where you get into the meats and bones, or meats and potatoes rather, of the offer. You can see here that there is there's required right away. That is the full 100% acquisition of that area. And in this instance, it's a 9,100 square foot area right away acquisition. They valued the property at $1.38 a square foot. As it turns out, that was an incredibly low undervaluation of the property. We got significantly more than that on negotiations with the DOT. That is just an example of how they undervalue the land. Going further, you have a permanent easement, which they will almost always need if there's a right-of-way acquisition, there's almost always a permanent easement as well. Not always, but most of the time. There, the permanent easement's 2,500 square foot acquisition at $1.38 square foot. Again, they did it by 60% because they're not taking the full rights. They're only taking an easement. We would argue that it should be 100%. Going further, you have these improvements that they're acquiring. They acquired a building, some paving, some landscaping. These are cost estimates to what these things are expected to cost. In this instance, they were, of course, low as well, low cost estimates, undervaluing what it would cost to replace these things and what they cost to take them down. And then there's a temporary demo easement as well. That's a small valuation for an easement to demolish structures on the property. But going further, you have this, again, here's the consequential or severance damage. We talked about this. They did offer some on this parcel, $12,000, almost $13,000. That was still very low. As I recall, this parcel had several parking spaces that were impacted. It was already a pretty condensed property, very tight property. And the issues were compounded by it being made tighter by the acquisition. That damage did not, it was way too low, and we got significantly more for that. As you can see, there is no compensation for lost revenue. There was a business on this property. They offered no business loss, and we had to recover that later. And then That's a but that is, I guess, the nuts and bolts. That is the offer. This is what it's going to look like. It's going to look a lot like this. There might be a comparable sales sheet they attach to it as well, but that's going to be it. And then also there's no discussion of the appraisal. One thing you're going to not find in this offer is that even though they did the appraisal, they came in the inspected the property, you are not going to see that appraisal. They won't give it to you. That's another policy of GDOT. They do not give these appraisals out. So don't expect to see it, which also makes things, again, difficult for you because you're kind of behind the 8 ball in this instance. Okay, and with that being said, we are to the attorney part of the presentation. Just a real quick example. If you're interested in hiring our firm, or if you think you might be, this is how our firm works. We operate on a contingency fee. You do not need to give me any money if you want to be my client. We just sign a contract, and our fee comes out at the end of the case whenever it resolves, whether it's litigation or otherwise. Fairly standard. If there's a $10,000 offer and you hire our firm and we get you $100,000, our firm would collect a third of the 90 that we add to the case, and you get the rest of it. If you hire our firm and we don't get you one more dollar than what is offered, we do not collect a fee. So I think that's important to note because we don't just take every case that comes in. If we take your case on, it's because we see some real recovery there, something that's going to be worth our time, and something that we can make some good increases on what is being offered, and something that is worth everybody's time. So just keep that in mind. If you come to me and you send me an offer and I look at it and say, this offer is great, and I don't think we can do much better, you can rest assured that that advice is honest, because I wouldn't tell you that if that wasn't the truth. If it wasn't the truth, I'd say this is a bad offer and you need to hire our firm so we can get you what you're entitled to. And then finally, we pride ourselves on our experience and our knowledge of the law, of course, and our ability to do our jobs. But ultimately, we are a results-based firm, and we judge ourselves on how well we do for our clients and how much more money we can get than what is offered, and how fair we can get the offer for our clients. So these are just some examples. I want to stress these are not guarantees of success. I'm not telling you that if you have a $15,000 offer that I'm going to get you $3 million. That did happen, but those are rare, to say the least. But these are, I think, more educational and elucidating of how bad offers can be from DOTs. Just because they do an appraisal, just because they are the state, just because you might assume some level of competence or this or that. These offers are often bad. These are, these cities, these counties, the DOT, they want to save money by any cost, and they will do that by lowballing landowners. It's something we see all the time. Our firm would not need to exist if the DOT came in and properly compensated all the landowners. If they did, we wouldn't need to have a job. We wouldn't need to be here, but nonetheless, they do. So we're here. So just something to keep in mind. These are just some real life results. We're not just all talk. And ultimately, this is, again, what we base our success on. So this is my last slide. I went a couple minutes over. I apologize. Moving forward, I would say, if you have an offer, the time to hire an attorney is now. If you feel like you're getting one soon, start vetting attorneys, start beginning that process. Once you get the offer, you should definitely contact an attorney. I'm happy to look at your offer for free. Like I said, do not rush. We talked about this earlier. Don't rush into a decision. If you can get a group together, and this is not required, but if you have a bunch of landowners who are in the same area, a bunch of neighbors, and they're all affected, and you all want me to represent you, then I can potentially do my job more efficiently, more effectively, if everyone's all together, and I can potentially lower my fee for groups that come to me. So something to consider, not required, but just something that if you can get together, then great. Then finally, there's only one chance of compensation. This is it. As soon as you sign the paperwork, you're done. That's it. There's no going back. Just make sure that whatever you're signing has been reviewed and you feel good about it and you've felt like you've done your due diligence so that you did your best in this scenario and you're coming out at the top. Don't be like your neighbors and other folks that just accept the first offer and move on and end up getting peanuts for the property. It's imperative that this is your chance, and there's only one chance, and make sure that you make the best out of a situation that you probably weren't asking for. And with that being said, I have reached the end of my presentation. That is my phone number. You can text that. You can call. You can also email me, jordan@landownerattorneys.com. If you have an offer, you can take a picture and text it to that number. If you have an offer, you can email it to that email address. And with that being said, I will see what this question is. There's a question about whether or not it's this presentation is just to get business for our firm. And I will admit, of course, part of this is to get clients, but also part of it is to educate landowners, which I think we have. So I think we answered that question. Are there any other questions? Okay, I do not see any other questions. So with that being said, I will go ahead and end this webinar. If you think of something later, feel free to email me or shoot me a text. Happy to answer it. Otherwise, good luck with your eminent domain acquisition, and let me know if you have any questions.